The camera, why is it off?
Because it's a record.
Thank you. Can you just place yourselves on record? This is a matter of Dedre Stein Physiotherapists Incorporated versus Stander Malay. It's opposed motion court.
May it please you, my lord, I appear for the applicant together with my learned friend, Mr. Marais.
Thank you, Mr. Bielefeld.
May it please the court, my lord, I appear for the respondent, Ms. Stander.
Thank you, Mr. Leroux. Yes, Mr. Bielefeld, we can proceed.
Thank you, my lord. My lord, this is an application to enforce restraint provisions. Your lordship would have seen from the agreement. It's essentially clause 19.4, although there's also relief sought in terms of clause 19.3 of the agreement. Your lordship will find those two clauses on page 30 of the papers. My lord, by way of introduction, it seems to us to be incontestable that the respondent is in breach of the provisions. It cannot be disputed that she is conducting a business contrary to the provisions of clause 19.4, at the very least, in that she's conducting a business of a physiotherapy practice. She does not deny that. I will later on turn to the provisions of 19.3. As I understand it, the respondent's contentions in terms of 19.3 simply boils down to the fact that there is no breach of that clause because the referring doctors are not what is referred to in clause 19.3 as associates to the business, but I will deal with that later. Lord, having that as a basis and having to accept, as I believe we have to, that there is a breach of the agreement, all that remains is whether the applicant is possessed of a protectable interest. Now, we know that protectable interest has various formats, and for our purposes, the formats which are required is firstly the goodwill of the practice. Your lordship, in that regard, may I refer your lordship to our heads in paragraph 26 of our heads.
Just give me a
And we
moment.
refer to the
Give me a moment, Mr. Bielefeld. Paragraph.
26, my lord, on page 10.
Yes.
Where it says it's accepted law that goodwill is part of an asset of an employer and becomes a trade connection of the employer capable of protection by way of restraint. And then there the famous case of Rawlins in the SCA is referred to. May I also refer your lordship, we've referred to the work of Sainer, the well-known work of Sainer on restraint of trade.
Yes.
In Sainer, if your lordship will make a reference to Sainer on page 7,
Yes.
/104.
Thank you.
Then attached to our heads is a decision which is often quoted in this division. It's a decision by His Lordship Mr. Justice Kroon. That is the
Okay.
Phillips decision. That's attached to it. If your Lordship would go to paragraph 39 of that judgment on page 19.
Give me a
Lordship
moment. Give me a moment. Yes.
Lordship will see in paragraph 39 what is regarded as a proprietary interest capable of protection is obviously confidential information, and then B, its goodwill and its relationship with its customers. So we submit that there is no dispute that at the very least on the respondent's own papers, there is no dispute that the practice of the applicant is possessed of customer goodwill. That brings us, my lord, to what we believe to be the essential element of the respondent's opposition, and that really, in essence, boils down to the following. What the respondent, in effect, says is that whatever connection you may have with these referring doctors and whatever relationship you've built up, my relationship with him, whatever it may be, and she vacillates in her papers, and I'll take your lordship to some passages, she vacillates in that regard as to the extent of it, but what is not in dispute is that there is some kind of a relationship according to her, but her defense is very simple. Her defense, my lord, is the following. She says, whatever relationship I've built up with him and whatever trust has been established between me and them, and whatever reliance they place on me, that is not as a result of your practice. It is because I conducted myself in such an exemplary manner during the time that I was employed that that is not protectable. And perhaps it's apposite that I take your lordship to some of these passages. On page 59 of the papers, paragraph 16.
Give me a moment. Yes.
Paragraph 16, in essence, encapsulates the respondent's defense, which is replete in the affidavit, in the other passages that I'll show your lordship. What she says, I submit that to the modest extent that I've built up relationships. Now, of course, it doesn't make a difference whether she built up modest extent or whatever extent with doctors, she say, and may suitably be placed to receive referrals from them. And I pause there to mention the proof of the pudding is, of course, in the eating. She did receive referrals. That is so on account of my own skills and attributes, and not as a result of any advantage gained as a consequence of my past association. So what she says is, I rely on the great work that I performed whilst I was employed. My lord, similarly on page 84, that is on paragraph 48.1 on 84. She says, it may well be so that there are doctors at the hospital who trust me.
Yes.
And she says, if so, that is not the result of my past association with the applicant or special relationship with those doctors. It would only be the result of building a good reputation by way of professionalism, hard work, and good level of skills. And then she adds on 48.2, it is so that I have received referrals from a number of such doctors. So there's no dispute that there has been actual referrals, but what she says is that the good relationship that's been built up and the trust that's been built up is because of my skills and the good work that I did during the period. Then, my lord, she tries to water down the relationship substantially. And if we turn to page 73, sorry, turn back to page 73, paragraph 33 to 5.
Give me a moment. Yes, I'm there.
She says, well, I'm in no position to divert the flow of work from the applicant. Well, she's already admitted that she's received referrals. Then she says, to the extent that I may attract a few referrals, it will not be as a result of past association with the applicant, but rather because I've hopefully over the years impressed doctors here and there with the quality of the work and my level of skill. So, my lord, in a nutshell, what she really says is because I've done such great work during the period that I worked there, that is why these doctors have built up whatever relationship there is and whatever trust there is, and not because of your practice. Well, my lord, that brings us immediately to the following question. The restraint that is being sought against the respondent is extremely limited in that it is limited to a single hospital in the entire Port Elizabeth. Nowhere in the papers.
Can it be accepted as common cause that Port Elizabeth has a number of other hospitals other than St. George's Hospital? Surely it can be accepted.
Yes,
that.
it must be accepted. And my lord, the respondent herself, and I'll revert to the question of the issue raised with a potential delay. The respondent herself at one stage wrote, as your lordship will recall, stating that she's going to work at Greenacres Hospital, and there has never been a problem to allow her to work at Greenacres. We all know there are other hospitals. There's Mercantile. We know that there are private practices all over Port Elizabeth. And that being said, the question is the following: why does the respondent insist upon wanting to work in St. George's as opposed to anywhere else in Port Elizabeth? And that rhetorical question, my lord, ineluctably can only be answered by the following. It is because she has built up a relationship with doctors at St. George's and wants to lean on that relationship to be able to prosper in her business in breach of the restraints. My lord, that brings us to the simple legal position. Is the contention by the respondent that these are her endeavors and therefore the relationship is not protected? Well, my lord, we really only have to refer to the well-known decision of Rawlins versus Caravan Truck, which is referred to by His Lordship Mr. Justice Kroon in the Phillips decision, and next to the heads on page 14 of the Phillips decision, paragraph 30.
Give me a second. What paragraph?
33 on page 14 of the Phillips decision. The principle is enunciated as clear and unambiguous as can be, my lord. It says, similarly, it was held in Rawlins versus Caravan Truck that customer goodwill was created or enhanced by performance of an employee of his duties in terms of his contract of employment was at least in part an asset of the employer. So her contention that it was her creation and that it was her performance that created this relationship is of no moment. Then it goes on to say, this case further affirmed the principle that the onus being on the erstwhile employer, and I poise there, my lord, to say that is clearly a mistake. If your lordship will read Rawlins Truck, it is not the employer, it is the employee. And I'll take your passage. To prove the unreasonableness of the restraint, it was for him to establish that he did not acquire any significant personal influence. I may just take your lordship to Rawlins. Rawlins, my lord, it is in paragraph 542 of Rawlins, where the appeal court, as it then was, said the onus being on Rawlins. Rawlins was the employee.
Sorry,
the unreasonableness.
What paragraph? What page 542?
542. Sorry, page 542. Sorry,
yes.
Not paragraph. Page 542. It says the onus being on Rawlins to prove the unreasonableness of the restraint. It was for him to show that he never acquired any significant personal knowledge of influence over persons he dealt with, etc., etc. The same applies in the present instance. My lord, that then brings us to the other and ancillary question, and that really relates to clause 19.3 of the restraint agreement, and that is the old contention that doctors are not business associates and are therefore outside any form of protection. Well, my lord, that argument is dispelled if your lordship will have regard to a relatively recent decision of His Lordship Mr. Justice Eckstein in this division. That was the decision of Hawkwind. It is in our heads, and my lord, Hawkwind, a similar position arose there in that the protectable interest was not the ultimate client in respect of which body works were being performed, but the insurance agents, such as in our case doctors, who referred work to the particular body works. And His Lordship Mr. Justice Eckstein found that was protectable. On page 9 of our heads, it's in footnote 19, and if Your Lordship will also have regard to our heads, page 16, paragraph 41.
Page
Where we
16.
say this, page 16, paragraph 41.
Yes.
Where we say the contention falls to be rejected in the face of the judgment in the matter of Hawkwind versus Goddard, where the ex-employer of a panel beating concern was interdicted from interfering with concern's relationship with the insurance brokers who referred work. Well, in our case, there's no difference between the insurance broker referring work or the doctor referring work. Lord, whilst I'm on that page 16 and 17, the passages in Rawlins and that are dealt with extensively on page 16, 17, and 18. And my lord, what must also be borne in mind is the contention by the respondent, somehow contradictory to her statement that there have been referrals to her, is to say, well, we haven't really suffered a harm. But of course, my lord, the legal position is, as we set out in our heads on page 13, paragraph 36, where we say, my lord, it is not necessary for the applicant to prove that it has lost customers as a consequence of the respondent's breach. All the applicant has to prove is that the respondent has joined a competing business or is herself competing in breach of the restraint. Opposite our case, my lord, that is exactly the case. Reddy's case in the SCA, which is the definitive of the general principles, repeats that. We repeat further on in the same paragraph, not necessary to show actual harm. But of course, my lord, in the present instance, the respondent has, in the answering affidavit, indicated that there have been referrals. She doesn't tell us exactly how many and how much money has been made. Of course, she's coy on that issue. So we even one removed, but we submit, my lord, the argument that there is no harm is not borne out by the papers, number one, and two, that in any event it is not a requirement. Lord, then there are one or two issues where in the respondents' heads of argument there are arguments which are based on, I don't know what to call it, my lord. It's certainly the arguments are not based on any fact or allegation made in the answering papers at all. One of those allegations relates to the question of why the respondent cannot work elsewhere for Elizabeth. What our learned friend says in the heads is that, well, you know, if she can't work at St. George's, we'll cut off her lifeblood and that will be the end. I've already...
There's no evidence to support that contention.
There's nothing to support that, nothing at all. And then, of course, perhaps more bizarre is the suggestion that the applicant's application is vexatious. Now, my lord, those are strong words to say to somebody who has an agreement which contains a restraint clause, to say that it's vexatious. But once again, your lordship will search in vain for any factual confirmation or backup to suggest that the application is vexatious. My lord, Then lastly,
it can't be vexatious in these circumstances. I mean, the applicant and the respondent has signed a restraint of agreement. One is expected to comply with the undertaking made, and once one intends to enforce that undertaking, how could it be translated to be vexatious? Clearly, it can't be, can it?
No, my lord, your lordship is correct. And what the respondent does, for instance, your lordship will recall that in the restraint provision, there is an acknowledgement that close relationships will be built up, which is protectable. And the respondent in her answering affidavit simply glosses over that and says, well, when I signed the agreement, we couldn't have known what was going to happen in future. So you must just forget it. But what is more significant, she does not deny the allegation. I think it's paragraph 46 of our papers. It's on page 17. Yes, my lord. Paragraph 46, page 17 says it says in terms of clause 19.1 of the contract, the respondent accepts that she has influence over the applicant's business associates. Well, she doesn't dispute that. What she simply says is, well, when we signed the agreement, we wouldn't have known what influence there would have been or would not have been. Well, that brings us lastly to procedural questions. Firstly, we are dealing with an interdict. The question of the requirements for an interdict, we submit that those requirements have been met. The only requirement which behoves some submission is the question relating to discretion. With your lordship's discretion, whether notwithstanding the other requirements, whether your lordship has a discretion not to grant the interdict. May I refer your lordship once again to Sainer on page 15, 100. Your lordship will also find this in Erasmus under D6-22 and 23. That's volume 2. But the principle is simply the following, my lord, and I'm going to read from Sainer on 1500, and it's repeated in Erasmus. The discretion of a court to refuse a final interdict once the 3 requirements have been shown to be present is very limited. The limits of the exercise by a court of such a discretion depend exclusively upon the question as to whether there is an alternative remedy which is adequate under the circumstances, and then refers to the well-known decision of Hotz versus UCT in the SCA. So, my lord, we say that the applicant has established all the requirements and is entitled to the release. Then the last procedural issue, my lord, is the question of delay. The respondent makes some issue as to delay, my lord, and in that context, one must really have a look at what happened. Your lordship will recall that there was initial correspondence and demands. What the respondent at some stage indicated was that she was going to work as a locum at Greenacres Hospital, which the applicant had no problem with. Shortly thereafter, the respondent's attorney or then attorney wrote and asked whether she could do a locum at St. George's. The applicant declined on the basis of the agreement, and it only really came to the applicant's notice that the respondent was working at St. George's after the December shutdown, and on the papers, your lordship will find it on pages 23 and 25. That was on the 13th of January 2020, and there were consultations and etc. And the application was launched in February. My lord, we submit that under these circumstances, the delay is not inordinate and not one of the types of delays where the applicant can be faulted. Your lordship will also see from the court file that the matter was originally on the roll in April. The matter was obviously removed at that stage because of the lockdown. So the applicant really couldn't do much more than that. The cases on delay, my lord, are set out quite neatly in SANA. I'll just find the reference. Lordship will just bear with me.
No problem.
SANA on page 1537. Under paragraph 15.8, the learned author deals with delay in the proceedings. And Lord, if we look at the cases, they refer to well-known cases such as Kemp versus Real Estate, a decision in this division, Turner versus Riddle. Lordship, the delays were inordinate. In the one case, for instance, the delay was nearly 14 months. And we submit that in the present instance, there simply is no ground to suggest that the delay was inordinate. The restraint provision, which relates to both 19.3 and 19.4, is for a short period. I interpose, my lord, to point out that the clause 19.3 in itself does not have the time period of 9 months in the agreement as 19.4. That's the provision which relates to the approaching associates, etc., to do business with somebody else. But my lord, in that regard, the respondent herself concedes in her papers that the 9-month period, if there is a protectable interest, would be a reasonable period, and your lordship will find that on pages 58 and 59 of the papers, paragraphs 14. It's paragraph 14 of the answering affidavit, where she says, halfway down paragraph 14, the outer limit of the clause, if enforceable at all, is the 9-month period that contemplates by the restraint provision of clause 19.4, and she says beyond that period of 9 months, the applicant is confined to other remedies. Well, my lord, we don't have an issue with that. Once we've convinced your lordship that there is a protectable interest, we submit that we're entitled to an order, both in terms of 19.3, which is effectively the order that's sought in paragraph 2 of the notice of motion, and paragraph 3 of the notice of motion, which relates to 19.4.
Make me understand, Mr. Bielefeld, paragraph 3 of the notice of motion refers to the respondent be interdicted for a period of 9 months from 1 October 2019 to June 2020.
Yes, my lord, that's what 19.4 says.
Which is in a couple of weeks to come.
That is a couple of weeks to come, my lord. Your lordship will see from the discussion on delay that I've referred your lordship to in SANA, there have even been cases there where the restraint period has lapsed, where the court has acknowledged that you're entitled to the order, even if it's for the question of cost, if you could make out a case. Obviously, if you couldn't make out a case. But my lord, at this point in time, there still is a clear right.
Yes.
Whether that clear right is watered down is neither here nor there. Of course, my lord, there are other reasons why upholding the restraint, if it is to be upheld, is important. Obviously, it sets precedents, etc., etc. But my lord, at this point in time, there still is a clear right. The matter has not become,
Become academic.
and until such time it's become,
Yes.
it's
So that's all what I wanted to
it's-
establish, that the period consent is only up to the end of, I think it's end of June, if one works then 9 months.
as your lordship please, that is correct.
Oh, thank you.
And that's all we're asking for, my lord. And we ask for, I'll just look at our heads. I'm sure we ask for costs in our heads. Notice of motion. Yeah, the respondent pay the cost of the application. My lord, we ask that the cost of the application include the cost of two counsel.
Thank you. Just a minute, Mr. Beresford. Mr. Leroux? Hello, Mr. Leroux? Hello? Mr. Leroux? Hello? Opusisanda. Hello? Mr. Leroux? Amhleka khange usisanda.